Seconds to go. Start. This appeal challenges the judgment and order dated 29 September 2021 passed by the High Court of Karnataka at Bengaluru dismissing writ petition number 53944 of 2016 preferred by the appellant herein. Said writ petition had prayed inter alia for following reliefs: issue appropriate writs, orders, or directions directing the respondents to produce mercy files pertaining to the petitioner, all the relevant papers and correspondence pertaining to the petitioner's mercy petition for the perusal of the court, since the petitioner has been able to show a grave and unexceptionable delay in such processes as undertaken by the respondents. Issue appropriate writs, orders, or directions directing production of medical file of the petitioner from prison from the date of his arrest. Issue appropriate writs, orders, or directions, and in particular a writ of declaration declaring that the execution of the sentence of death on the petitioner as communicated through letter dated 15th May 2013 pursuant to the rejection of his mercy petition by the office of the Honorable President of India is unconstitutional and bad in law. Issue appropriate writs, orders, or directions commuting the death sentence of the petitioner to imprisonment for life. Declare that the decision of the office of the Honorable President of India rejecting the mercy petition filed by the petitioner is illegal, void, and unenforceable. Declare that the decision of the office of the Honorable Governor of Karnataka rejecting the mercy petition filed by the petitioner is illegal, void, and unenforceable. Quash and set aside the order of President of India rejecting the mercy petition filed by the petitioner. Quash and set aside the order of the Governor of Karnataka rejecting the mercy petition filed by the petitioner. Grant inspection of the documents mentioned in A and B to the petitioner. Issue any such other writs, orders, and directions as this Honorable Court deems fit in the facts and circumstances of the case in the interest of justice and equity. The basic facts leading to the filing of said writ petition are as under. 1. Jaya Shri was found raped and murdered in her home on 28th February 1998, which led to the registration of crime number 108 of 1998 with Pinya Circle Police Station, Bengaluru City. The appellant was arrested in connection with said crime on 2nd March 1998 and has been in custody since then. After due investigation, the appellant was tried in Sessions Case number 725 of 1999 on the file of Sessions Judge Fast Track Court 7, Bengaluru, for having committed offences punishable under sections 302, 376 and 392 of the Indian Penal Code 1860. By its judgment dated 26 October 2006, the trial court convicted the appellant for the aforesaid offences and by order dated 27 October 2006, awarded punishment of death sentence subject to confirmation by the High Court. The appellant was immediately transferred to Belgaum Central Prison and according to the appellant, he was kept in solitary confinement. Case for confirmation of death sentence was registered as criminal reference number 3 of 2006 before the High Court. The appellant also filed criminal appeal number 2408 of 2006 challenging his conviction. The matter was heard by a bench of 2 judges which confirmed the order of conviction but disagreed on the sentence to be imposed. While Mr. Justice V.G. Sabhahit confirmed the award of death sentence, Mr. Justice R.B. Nayak commuted the death sentence to life imprisonment. The matter was therefore referred to the third judge, that is Mr. Justice S.R. Banur Math, on the issue of sentence, who affirmed the award of death sentence by his judgment dated 18 February 2009. The matter was carried further by the appellant by filing criminal appeal numbers 285 and 286 of 2011 before this court, which were dismissed by this court, while order dated 1st February 2011 affirming the appellant's conviction and sentence of death imposed upon him. According to the procedure governing petitions for mercy in death sentence cases, a death convict can prefer a petition for mercy within 7 days after the dismissal of his appeal by this court or rejection of application for special leave to appeal. The relevant instructions in that behalf read as under: a convict under sentence of death shall be allowed, if he has not already submitted a petition for mercy, for the preparation and submission of a petition for mercy 7 days after and exclusive of the date on which the superintendent of jail informs him of the dismissal by the Supreme Court of his appeal or of his application for special leave to appeal to the Supreme Court. Stop.